I'd like to turn the conditional use hearing over to our distinguished hearing officer.
Thank you, Mr. Chairman. We're here tonight on the continued hearing of Three Creeks LLC. This is a conditional use hearing for proposed traditional neighborhood development to be located at 2069 Bondsville Road. We last met on April 17th of this year, and I think at that time we finished the examination of Mr. Boyer, one of the applicant's witnesses, and I believe Ms. Dunn, who was here, indicated that she may have one or more additional witnesses. So you have the floor, Ms. Dunn.
Thank you. Just for the board's knowledge of what's going on compared to how we left it last time, I am going to wrap up the applicant's case in chief with Mr. Winters, just to basically get some additional documents into the record that are in the binder that has been provided to everyone, so nothing new in terms of the proliferation of these, just to, they should be in front of you. And then I believe we had discussed at last month's hearing as well, that then it would be Mr. Foley's intention to call Joseph Boldaz from the Municipal Authority's environmental consultant firm, and I will let Mr. Foley sort of tell you where we are on that.
Yes, thank you. I emailed council this morning to let her know that after having reviewed the Act 537 plan, I think it speaks for itself. Therefore, I don't plan to call Mr. Boldaz to testify about it. I'm pretty sure that Luke can identify the documents and perhaps provide some testimony about what the process was for its adoption. So my witness tonight would be Luke, and at a later date, which I think we're about to tell you is 2 months from now, we'll call the township engineer, Nate, and that would constitute the township's presentation.
Can you move the microphone a little
sorry.
closer to yourself?
So what the parties anticipate tonight is that we would hear from Mr. Winters, and then that would conclude your case in chief. And then Mr. Foley intends to call the township manager, Mr. Revin.
Correct.
And I saw an email earlier today that Mr. Klein, the township engineer, is not available on June 19th, which would be what we would typically continue the hearing to. So is he available on July 17th?
He is.
Would you be agreeable to continuing the hearing till July 17th?
Only because I like Nate, yes.
Well, we appreciate that. Okay, with that, then we can proceed, please.
Just to clarify that, that consent to that postponement for 2 months is a waiver of the 45-day requirement under the MPC.
It is a waiver, and if you need something in writing, that's fine, but if this is fine on the record, since we have a court reporter, just let me know what the township wants.
If memory serves, I think because of the long delay in commencing this proceeding, Mr. Winters waived all those requirements at the outset.
Oh, okay,
But I'll check.
okay,
Thank you.
certainly.
Thank you.
Just as a point of order, what time on the 17th?
Well, at the end of this evening's hearing, we'll state it for the record, but the intention is to commence the hearing after the conclusion of the Board of Supervisors meeting on July 17th, which begins at 6:30 p.m.
I just want to make sure the room is free.
Thank you.
All right, may I proceed?
You may.
Right, Mr. Winters is our final witness, just to do some wrap-up here, and I do believe he was placed under oath.
He was, and we consider him still under oath.
Okay, Mr. Winters, you're still under oath, And as the representative of the applicant, the authorized representative of the applicant, I'm going to ask you to first turn to, or I will turn here.
Oh, and
Oh,
I'm,
can I have Mr. Winters remain here so that we can share this exhibit book?
you may, and I just want to note for the record, you'll see that Mr. Scribner, Supervisor Scribner, is not in the room this evening, but he is participating remotely. Can you hear us, Mr. Scribner?
Yes, I can, and I have no problem with Jason sitting with her.
Okay, very good, thank you.
Mr. Winters, I'm going to ask you to look at what has been pre-marked as applicant's exhibit 23. And after you have an opportunity to look at that, please let me know if you've ever seen this before.
Yes, I have.
Okay, for the record, it is a letter dated February 15th, 2023 from Three Creeks LLC to the Board of Supervisors of East Brandywine Township. And if you could just explain briefly the substance and purpose of this piece of correspondence.
This correspondence was sent out by the members of Three Creeks to request a hearing prior to the board adopting Ordinance 1 of 2023, the adoption of the official map.
And in terms of that ordinance, Resolution 1 of 2023, what was the opposition or objection of Three Creeks to that particular ordinance?
The objection was that the new official map depicted a proposed Reesville Road extension transversing through the property, and it took up too much property, and the members did not want that road to be laid out on the map because they presented that property had presented a sketch plan in 2019, and the township had an opportunity.
You got to speak into the microphone,
The
Chase.
township had an opportunity to purchase the property, and they did not within the 2-year limitations, so they didn't want the road to be included on the new map.
Okay. And by they, you mean Three Creeks?
Yes.
Turning to applicant's exhibit A24, can you identify that document for the record, please?
This is the members of Three Creeks appeal of the adoption of the official map, Resolution 1 of 2023.
Okay. And this was filed in the Chester County Court of Common Pleas?
Yes, and it's currently pending.
Okay. Has Three Creeks engaged in any discussions with the township in terms of this case? That you know? You know? Okay. Turning to applicant's exhibit A25. So represent to you our work session notes from the Board of Supervisors for East Brandywine Township dated April 4th, 2019. Have you ever seen this document before?
Yes.
And what is the significance of these minutes with respect to this application?
These minutes reflect that the township traffic engineer at the time, Andy Heinrich, had voiced his concern over the township's lack of planning and adherence of their Act 247 traffic impact fee ordinance. And he was concerned that the capital improvement loop road that extended from 322 all the way down through the property and back to 322 was not included on the Weaver final land development approval plans, and therefore the township, he was concerned that they're collecting money from developers and not adhering to the plan.
And for the record, are you referring to the minutes that are reflected starting on page 3 of this exhibit A25?
Yes, towards the bottom.
Okay. And did Mr. Heinrich also speak in terms of his concern about the Township's Act 209 study?
Yes. It did not include the roundabout or the Reedsville Road extension project on its
I'm
own.
sorry, Jason, you're gonna have to try to keep your voice up.
Voice up.
Please.
I don't know what's going on.
Nobody ever asked me to do that.
Okay, I'll speak louder.
Okay.
Thank you.
Turning to what has been marked as exhibits A26, which are also session minutes for the Township Planning Commission dated June 5th, 2019. Have you seen these minutes before?
Yes, I have.
And what is the significance of this document with respect to this application?
This document just shows the planning commission agenda for the June 5th meeting and include the sketch plan submission and review of this property.
And specifically on this, I'm looking on the page. Where do you see?
Towards the top
At the top.
on the agenda.
It's identified as 2069 Bondsville Road sketch plan submission.
Yes, it is.
Sorry, where are you seeing that?
It doesn't, it doesn't say Three Creek.
Got it.
Right, turning to applicant's exhibit 27, which are regular session minutes for the Township Planning Commission dated June 5th, 2019, and I would note that on page 1, the sketch plan that you referenced in Exhibit A27, 2069 Bondsville Road sketch plan is noted in here with a discussion, correct?
Yes.
And on page 2 of Exhibit 27, do you recall at that time whether or not any discussion was held with the Planning Commission with respect to the availability of public sewer for the proposed project?
Yes. Member Corbin was present at the meeting, who happens to be a member of the municipal authority, and he believed that capacity was available and it would be likely a matter of just tapping into the line.
Okay.
I'm sorry, likely be a matter of what?
Tapping into the line going to the pump station.
Okay. Turning to Exhibit A28. Have you ever seen this correspondence before?
Yes.
And it is a letter dated July 14th, 2015 to John and Jason Winters from Township Manager Scott T. Pearsall. You recall having received this correspondence around that date.
Yes.
And what is the significance of this correspondence with respect to the application?
It was the township manager just letting us know that they're doing a study for the proposed Reedsville Road extension, and that he just wanted to let us know that there could be some surveyors walking around.
And did you have any objection, or did any member of Three Creeks LLC or the then current or the then owner of the property object to that?
No, they did not.
Turning to applicant's exhibit 29, appears to be an email string dated September 27th, 2017, and initiated by Scott Pearsall at 12:21 p.m. to Willis Spence. Have you ever seen this email before?
Yes.
And what is the significance of these emails to this application?
This was my uncle, Will Spence, contacted the township manager to ask questions about his intention of getting a building permit to build a home on that property, a single home.
And at that time, was Willis Spence the legal owner of the property that is subject to this application?
Yes.
And what came of that proposal?
It was just, really just the township manager's thoughts on it and what he had to do, a little more research. But there's no mention of the Reese Road extension at all going through the property.
I'm sorry, did you say Willis Spence was the owner?
I
Then?
believe so. I believe so.
Okay, I couldn't hear you, that's why. Thanks.
Turning to applicant's exhibit 30, which is correspondence dated April 10th, 2019 to John R. Winters from Scott T. Pearsall, then Township Manager. Have you ever seen this correspondence?
Yes,
And who is John R. Winters to you?
he is my father.
And at this time in April of 2019, was John R. Winters a legal owner or an equitable owner of the property in question?
Yes, he was.
And what is the relevance of this correspondence to your application?
It was the township,
Expressed interest in purchasing that property for their future planning needs.
And I would also just note that that correspondence indicates that Mr. Pearsall proposes the initial step of having an appraisal done. To your knowledge, was there ever an appraisal completed for the property?
yes.
Turning to applicant exhibit 31, is an email dated April 29th, 2019, from Scott Pearsall to Kristen Camp, Jay Fisher, Kyle Scribner, and Luke Revin. Have you ever seen this email before?
Yes.
And what is the relevance of this email to the application?
The township manager,
Discussing the sketch plan in 2019 before the planning commission.
Okay. Turning to exhibit A 32. Is an email dated June 3rd of 2019 from Scott Pearsall to Mr. S.C. Kristen Camp, and it appears that's it. Have you seen this email before?
Yes.
And what is the significance of this email to the application?
They're discussing the previous owner's submission to the planning commission for their sketch plan review with the township.
And at the very bottom of that page 1 of exhibit A32, do you recall Mr. Pearsall initiating a discussion about the township's continued interest in the acquisition of the reference property?
yes.
Turning to applicant exhibit 33, is an email dated October 1st of 2020 from Scott Pearsall to a Molly Dieter. Also CCing Nate Klein and Joseph Boldaz. Have you ever seen this email?
Yes.
And do you know who Miss Dieter is?
No, just a prospective buyer of the shop. She was interested.
A prospective purchaser of the property subject to this application.
Yes.
And you know the introduction of the email reads Molly and Mike. Do you know who Mike is?
No, I do not.
And what is the significance of this email to the application?
They're discussing plans, what they would like to do with the property.
When you say they,
Mike, Molly and Mike, I believe Mike was Molly's husband, and they wanted us to do some kind of brewery there, even though it's already under contract, not for sale, at the time. And it was just discussing the various aspects about the property, and it mentioned how the Reesville Road extension does not transverse the actual parcel, but it actually goes across the north of the Bobby McHugh's parcel to the north, as the current conditional use applicant's sketch plan depicts the road.
and does Mr. Pearsall take a position with respect to his wishes regarding the potential purchase of the property by Molly Deeger? Specifically, I would draw your attention to the second to last paragraph on page 1.
Yes.
And what was Mr. Pearsall's opinion on the matter?
He's discussing the sewer with Joe Boldez.
And does he say, if you decide to proceed, and I hope that you are able to do so?
Yes.
Turning to applicant's exhibit 34, appears to be an invoice dated May 6th, 2019. I believe that's May 6th. Is that May 6th? 2019, from Buckley Bryan to East Brandywine Township. What is the significance of this document to the application?
It just shows that
The township had paid our solicitor to draft agreement of sale for the purchase of this property.
Okay, and can you please, for the record and for the board's convenience, identify which page and which entry?
yes.
So there are page numbers at the top right, which,
It's the page 3. And it's it go all the way to the very
Bottom, it's the fourth line item up on April 25th, 2019, prepared initial draft of agreement of sale for 2069 Bondsville Road.
for the record, I believe it's April 26th of 2019.
Oh, okay, what did I say?
I think you said the 25th.
Oh, I'm sorry. Oh, okay.
All right, turning to exhibit A35. What is the significance of that?
This is the planning commission.
Solicitor being compensated for reviewing the applicant's sketch plan 2019.
Dated 7/5 of 2019, correct?
Yes.
And just two more. Applicant's exhibit A36, which is titled Assignment of Contract for Purchase of Real Estate. Have you ever seen this document before?
Yes.
And is this, well, why don't you explain the relevance of this to the application?
J&J Partnership had the property under agreement, under contract, and then assigned it to Three Creeks, purchased the contract from them.
Okay. And when you refer to J&J Partnership, that was a partnership between the previously referenced John R. Winters and Willis Spence, including 2 other individuals as well, correct?
That was the actual owners at the time, but the actual buyers were J&J Partnership, who was John Winters and Jason Winters.
And then the assignee was Three Creeks LLC.
Correct.
All right, turning to A37, which is an affidavit of a Denise Frame. Have you ever seen this document before?
Yes.
And what is the significance of this to the application?
Denise Frame was the realtor who helped with the transaction for the purchase for Three Creeks, the applicant, and it just acknowledges that the township had approached and attempted to purchase the property back in 2019. May 1st, 2019.
And this is dated November 15th of 2023. Which is later in time than the assignment that we just looked at Exhibit 36. And item number 10 in this affidavit appears to indicate that following that discussion with the township solicitor in May of 2019, Ms. Frame did not hear back from the township up until the date of the execution of this affidavit. Is that accurate?
Yes, that is.
And does that comport with your understanding as well?
Yes.
And the last one, I would ask you to turn to applicant exhibit 43. Oh, you know what? We don't need to do that. That's fine. I do not have anything further, and I would ask for the admission of my exhibits with the exception of A43. I do know that Mr. Foley, in his pre-marked exhibits, has provided an official copy, well, a copy of the Township's Act 537 Sewage Facilities Plan Update. And with respect to the outstanding objection to our Exhibit A15, my understanding is that Mr. Foley's copy has additional footnotes that are not contained in the Table 5.2 that we provided the board at A15, and I'm fine with not moving our A15 into the record and relying upon the substitution of Mr. Foley's exhibit, if that's not too complicated.
So you're moving for the omission of, and I'll try to do it this way, A1 through A45, except for, I thought you said A43 and A15.
Correct, with the caveat that I'm only withdrawing A15 if it pleases the court to substitute, for all reference purposes to the record, Mr. Foley's Exhibit T4.
So, Mr. Foley, you intend to offer as evidence the complete Act 537 plan that's at issue?
No, just the relevant, what we believe to be the relevant portion of that. Exhibit T4 is a copy of the cover page for the Act 537 updated plan, as well as a complete copy of Section 5 entitled Alternatives contained within the plan. And contained within that section is the chart, the actually officially adopted version of the chart that's been referred to.
Well, let's do this then. In my folder, Exhibit A43 appears to be Mr. Winter's resume.
Yes, I don't know if the CV, we just had CVs for everyone, but I advised him that I don't think that we admitted him for any expert testimony.
Okay, very good. So we have a request for admission of A1 through A45, except for A15 and A43. Is there any objection?
There is. Object to the admission of the records from the township meetings to the extent that they contain hearsay statements being offered for the truth of those statements. I have no objection to the documents coming in. Can stipulate that they do in fact appear to be copies of the official minutes and of the various emails referred to. The other point I would like to request to just check my notes with regard to whether each of the other listed exhibits were in fact referred to during the testimony in this matter. I'm certain they were, or council would have circled back today. But if I could respond to the request for admission in writing, I'd appreciate that.
Okay, do you mind if we defer that decision until we hear from Mr. Foley, so we don't take up a lot of time this evening?
I do not, and if it makes it any easier for you, Mr. Foley, and eventually for Mr. Esty, obviously, with respect to the hearsay that may be embedded within township minutes, I don't believe that necessarily requesting the board to accept statements made in those minutes is the truth of what is asserted by the speaker, so much as that these discussions were held on the dates in question.
Very good, understood.
Understood. Thank you.
May I say something real quick?
Yes,
The only question I had pertaining to the exhibits were, are those exhibits all coming from right to know requests?
No, certainly not. I mean, with respect to the minutes, perhaps some of them are, for example, the affidavit of Denise Frame that we just reviewed were documents originally in the possession of the applicant, including the agreement of sale, the assignment.
I'm more referring to the email portion of the exhibits.
would it be accurate that, I mean, we can acknowledge that Mr. Winters at one point was a township supervisor, and would it be accurate to say that some of those emails came into his possession as a township supervisor?
Yes, well, I'll let him answer.
I'm not implying
Yeah,
there was anything
I was told
wrong.
I was told as a township supervisor that, any document that doesn't have the attorney-client privilege on it is a public document. And I actually, we had actually spoken to Kristen Camp back then to confirm.
And I don't recall any right-to-know requests for these documents, but
Well, there was 3 right-to-know
some
requests.
things I don't recall, so.
The applicant did submit 2 right-to-know requests. I know the last one was very vague. It just said, any documents concerning 2069 Bondsville Road with the parcel number, and any documents concerning that property, and it was denied because there was none.
Okay, I just question if even as a supervisor, someone has authority to emails that he or she may not have been engaged with in the conversation. So I just wanted on record, I just wanted to make sure that, these were received through right to know requests, or sometimes they were received with other methods, and that's what I want to clarify, what method they were received.
So you're saying that you're saying that at the time that there was communications with only 2 board members and not the third.
Well, let me just,
You're concerned about that?
I don't want to get into it.
No, I'm not saying that at all. What I'm saying is I want to make sure that these emails had the recipients that were involved in the email. I mean, it would say on the email exchange who were involved with them.
Well, I would.
Let me try to do this. Is it accurate to say that some of the emails came into the applicant's possession through Mr. Winters in his capacity as a township supervisor?
Yes.
Would that be accurate, Jason?
I would think yes. Yeah.
Okay, and some of them, some of the emails came into your possession, the applicant's possession, as a result of responses to right-to-know requests.
That's correct, and then maybe even for purposes of exhibit.
The minutes and everything were from right online.
Right. Some of the minutes were taken off the township website.
And then there was one email that was a communication from the township, the then township manager, to the potential purchasers of the property.
And again, I don't know that there's
Whether or
any.
not he received it from the purchaser, I'm just making the clarification that there are a variety of reasons.
Understood. Okay, thank you. Okay, so you're resting your case in chief, subject to a determination on what exhibits will be admitted into the record. And Mr. Foley, we'll hear from you on the issue of admission when we convene the next hearing.
Yes, thank you very much.
Thank you. I'm sorry, were there any questions from the board regarding Mr. Winter's testimony?
I have none.
Okay, thank you. Mr. Foley?
Yes, I actually have questions of Mr. Winters, but they are not about the list of exhibits that were just now entered. So I wanted to ask him about the sewage capacity by reference to the actual chart that's included in the 537 plan, slightly different from the one that we had been looking at until today.
So you did hand up some exhibits to the board and myself prior to the commencement of the hearing, and somewhere in this list, I guess, is the document you're referring to.
Yes.
Which exhibit is that, Mr. Foley?
Yes, let me represent that the township manager will identify our exhibit T as in Township 4 as a true and correct copy of the cover page of the Act 537 Sewage Facilities Plan Update and a complete copy of Section 5 of that update entitled Alternatives. At page 5-9 appears Table 5-2, which is the
I'm sorry.
document in question.
Ms. Dunn, do you have any objection to Mr. Foley asking Mr. Winters questions about this now, or would you prefer that those questions occur after this document is identified by Mr. Revin?
I'm willing to sacrifice formality in the interest of efficiency, certainly. To the extent it's outside the scope of anything I ask Mr. Winters, I'll just wait and see how it goes, I suppose.
Okay, I could call him as on cross if you prefer. Yeah, I know.
On this testimony,
Okay.
whenever.
You have any more questions about what Mr. Winters testified about tonight?
No.
Okay. I think Mr. Supervisor Taraski has a question.
So, Jason, you testified that on April 10th, John received inquiry from the township about the interest in purchasing the property on one of your exhibits. And then on April 29th, a sketch plan was submitted to the township 2 weeks later.
Mm-hmm.
Okay,
Yes.
thank you.
Is that not, you're not allowed to submit sketch plans?
I'm just asking the question, that's all.
Oh, okay.
It's yes, no. That's all.
Okay, thank you. Mr. Foley?
Yes, thank you. Good evening, Mr. Winters. Drawing your attention to, I've given you a copy of page 5-9 of what will be identified in a few minutes as a copy of a section of the Townships Act 537 plan, substantially similar to your exhibit. I believe it's A15. I just wanted to draw your attention to the footnote A, which is at the designation of the footnote is at the very top right-hand corner of the document, and then the footnote itself below that reads, quote, assumes that disposal capacity is been, I think that's a typo, perhaps it should have been the word being, provided in accordance with Township Code Chapter 350.47, comma, Municipal Authority Resolution 01 of 2017, comma, Section 406. I'm not trying to test your memory, but is it your understanding that those sections are the township's requirement that projects provide 150% of the recharge capacity or the discharge capacity that's required of the individual project?
I'm not really certain, but I know for this property, at the very start of the creation and the planning of Applecross development, they had the village of Guthersville, and in 2011, Hopewell neighborhood and Guthersville was being, the township wanted to divert the flows from Little Washington sewer plant to Pump Station B, so that way they could start utilizing Applecross. And in order to do that, they had to do a study of the potential build-out of the village of Guthersville based on the zoning and based on the potential of the highest sewage treatment needs. And this property was included in the Guthersville flows early on as part of that.
I guess my question about the document is on both your version and this one, under the heading about halfway down the chart of Winter's Tract, after reciting that it had a maximum of 21 units, there's two figures. One is 3,675 gallons per day as a negative number, and then in the next column to the right, a positive number of 1,838 gallons per day, which is exactly 50% of the first number. Is it your understanding that the township's ordinances and the authority's resolutions require 150% of discharge capacity be provided by each developer?
I would only object to the extent it's a legal concern, but Jason, if you know, you feel comfortable answering.
I don't even know what the real question was. As far as the 50%, the township require that?
150%.
150%, yes. I think the township ordinance does require 150%. And if you're in the village of Guthersville, and you don't have, obviously the village of Guthersville, you don't have the land for that, you have to pay a fee in lieu of. And our engineer had spoken with Joe Boldez from the municipal authority, and that's what Joe has recommended, that we'd have to pay a fee in lieu of.
I saw that in the resolution. It says that a fee in lieu may be considered. That's a quote. My question is, have you or anyone approached the authority itself as to whether or not they would in fact consider a fee in lieu?
In 2019, I believe it relayed to us that both disposal and treatment was available.
I'm sorry, that both?
Both treatment and disposal, and the disposal of the treatment was both available to that property.
So disposal somewhere off-site?
Correct. At Applecross, yes.
And would your understanding be that would be in return for a fee in lieu?
Yes, similar to the learning center, or that daycare center on the hill.
Although that's not a residential development, correct?
No, but it's within the village of Guthersville at the time of the study. It could be a development.
It's perhaps overstating the obvious, but are we all clear that this property itself is not suitable for discharge of sewage effluent on site?
I think that it does not go through for everybody.
You have to keep your
Both
voice
of
up.
you speak up. You can't-
I don't think that
you're
the
speaking
property
to
is
each other.
suitable for
Nobody
treatment
else
of
can hear
sewage.
you.
We'll repeat the question. Are we all in agreement that we understand that this property is itself not suitable for on-site discharge of sewage effluent?
I would have to agree based on the soil tests.
Thank you. That's all I have.
Just one clarification for the record, in your answer to Mr. Foley's question directly before his last question, you indicated that there was a positive requirement for 150% disposal capacity per township ordinance. Did you mean to say per municipal? municipal authority resolution?
Yes, because we go by that.
Well, I guess I happen to know something about this, and just to make the record clear, both the township subdivision and land development ordinance and the municipal authority regulations require that the applicant's property provide disposal capacity of the treated sewer effluent based on 150% of what's being discharged into the system.
Correct.
Okay. Into the municipal authority system. Thank you.
Thank you. That's our understanding as well. That's all I have of Mr. Winters.
Thank you. Any other redirect, anything else?
No.
Okay, very good. Mr. Foley,
Yes.
proceed with Mr. Revan's
Yes, I would
testimony.
call Mr. Revan to the stand.
Just that, and then I'm gonna grab that microphone.
Do you swear or affirm to testify about the truth, the truth, the whole truth, and nothing but the truth?
I do.
Mr. Revan, for the record, you are the township manager,
Correct.
and for how long has that been true?
Became the township manager in January of 2021.
And so you were the township manager during the consideration and approval of the township's Act 537 plan update that was finalized in March of 2023 and approved by DEP in January of 2024?
It was a long process. I was not at the beginning, I was at the end.
Thank you. Therefore, can you identify our Exhibit T4 as, excuse me for leading, but as being a copy of the cover page of the March 2023 final Act 537 Sewage Facilities Plan Update, as well as a complete copy of Section 5 of that plan entitled Alternatives?
Yes,
Thank you. Were you involved in the process of the final approval of this plan?
I was.
Can you generally explain to the board what I believe there are 7 alternatives discussed in this section of the plan. They are lettered, not numbered, A through capital G.
Right.
Not going to have you explain each one in detail, but can you start with alternative A?
Well, certainly. If I may, just a 537 plan is an exercise in identifying future sewer needs. The future sewer needs could come from failing systems that exist or from anticipated future use. A 537 plan then proposes a series of solutions to address those future sewer needs. I'm looking at Table 5.1. The top column is alternative A through G. Those are alternatives that were proposed by the design consultant.
Very well. I'm looking at page 5-2, where the titles of those various alternatives appear. Item A is Public Sewer to Applecross Regional Treatment Plant. And later in the document, I believe that's the one that is identified as being the most suitable for the Winters tract, correct?
May I first characterize what alternative A represents?
Please.
Alternative A represents a solution to future sewer needs by routing those failing systems and new growth to the Applecross wastewater treatment plant. If you're referring to what was the exhibit that has been withdrawn and now is likely to be readmitted as page 5.9 of this,
Yes,
table 5-2 references alternative A.
yes.
It is a constituent part of that solution.
And likewise, on page 5-5, where the focus area alternatives are listed, the Winters tract appears about halfway down that chart. And the only X appearing in any of the columns as to the Winters tract was alternative A, public sewer to Applecross Regional Treatment Plant, correct?
I'm sorry, I was looking at table 5.5. I'm now looking at page 5.5, table 5.1. And yes, I can confirm that the only X that appears in the row, Winters tract, appears under alternative A.
Thank you. Then by reference, back on page 5-2, alternatives B as in boy, C and D as in dog, all relate to proposed improvements and expansions of the other three existing treatment plants. Is that accurate?
B and C in particular are two wastewater treatment plants operated by the township's municipal authority. D is a wastewater treatment plant operated privately.
Could you explain what item E is on page 5-3, or alternative E?
I will read directly at the risk of mischaracterizing it. Option E is individually owned and operated small flow treatment facilities. So this solution would propose to address sewer facilities or anticipated sewer needs through these decentralized small treatment facilities.
Specifically by both allowing them and perhaps encouraging them.
Correct.
And likewise, item F.
Correct. F makes a little more sense in the context of dealing with future need, as in encouraging the township to encourage community on-lot disposal as a means to address future land development.
Very well. And finally, alternative G entitled Sewage Management Program.
The sewer management program here is the most detailed description because it is ultimately the option that the township chose to address future sewer needs. The sewer management program would ensure that future needs be routed to the Applecross wastewater treatment plant and any failing systems be addressed through the implementation of a program to detect and address failing on-lot systems.
I think you may have just said it, but of the 7 alternatives that were considered, which one or ones were ultimately adopted and approved?
G.
Only G?
Only G.
Alternative A was not adopted.
Correct.
Therefore, table 5-2 submitted by the applicant, which is part of alternative A, is not in place as an approved portion of the plan.
It was an exercise done to explore implementing option A, but it has no relevance to the adopted plan.
Directing your attention to exhibit T5, for the record, I'll acknowledge that the highlighting is mine, not original. Can you identify this document?
This is a letter dated January 25th, 2024 on Pennsylvania Department of Environmental Protection letterhead.
Is this part of the township's official business records?
Yeah, yes, I would characterize this as the approval from DEP of our 537 plan.
And in fact, that's the first highlighted sentence ending with "the plan is approved," correct?
Correct.
Consistent with your testimony, the second highlighted sentence explains what the plan as approved calls for, yes?
Yes.
And then finally, the third highlighted sentence recites or ends with the statement that, quote, "no expansion of the sanitary sewer system is proposed." Is that accurate as to the DEP's characterization of the plan?
Yes, it is. It is reflecting what the township opted as a solution to our future sewer facilities needs and agreeing with the township's recommendation.
As to this application, other than the applicant's submission of a copy of Table 5-2 being part of Alternative A, has anything else been submitted to you or to your knowledge to the township to show the feasibility of expanding the sewer system to serve the Three Creeks property?
I'm going to speak to component parts of the original conditional use application submitted by the application. I recall no additional documentation that sewer was feasible other than a version of Table 5.2.
Anything submitted to show the feasibility of providing 150% of the land area needed for disposal of the effluent generated by 21 townhouses?
As I testified, the only documentation I recall seeing is a version of Table 5.2.
Thank you. I have other questions on a completely different topic for Mr. Raven. May I suggest that to keep the record clear as to topic by topic, that if the board or if there's cross-examination about the sewage issue, we do that now?
Can I ask for a 5-minute break?
Yes, that's fine. We'll take a 5-minute break. Thank you. So we'll proceed now with the cross-examination of Mr. Revin on the issues about the 537 plan.
Mr. Revin, you testified that you were involved in the formulation of the Act 537 plan that is marked Exhibit T4, correct?
Yes.
And what was your function or role in the formulation of the Act 537 plan?
Sure. So the Act 537 plan is a township plan, but since sewer facilities are in East Brandywine that are public or operated by municipal authority, a committee was formed to develop the 537 plan. And I served on that committee that was a combination of township staff and municipal authority members in developing it. As an example of a task, there was a survey sent to homes where they would self-report any on-lot system failures. I helped develop the survey, send the mailings, and code the answers when they came back.
And with respect to the committee that you referenced, I believe you testified earlier that there's at least one wastewater treatment facility that is privately owned. Is that accurate?
In East Brandywine Township, yes.
And was there any representative of that private wastewater treatment facility on that committee?
No.
Why not?
Before you mentioned it to me, I wouldn't have anticipated. It never occurred to me.
You referenced a design consultant. Who was the design consultant for T4?
For T4, it was Hydroterra, the township's the sewer authority engineer.
So it is both, Hydroterra serves both as the municipal authority's engineer and also served the function of design consultant.
For this project, yes.
And how long has Hydroterra functioned as the municipal authority engineer?
Their involvement predates my joining of the township in 2014. Sometime longer than that.
So at least as far back to 2014?
Yes.
Okay. And prior to the adoption of the Act 537 plan at T4, was there an Act 537 plan in place?
I don't know.
So in other words, do you recall whether or not the formulation of this was a brand new venture, or if you were making modifications to an existing Act 537 plan?
I can tell you, based on familiarity with the records, that if a full copy of Exhibit T4 were in front of us, the table of contents would have a complete list of prior planning exercises.
Mr. Bevan, would it be possible to put your fingers on that full version somewhere here without too much inconvenience?
It would be difficult for me to make copies of the bound for everyone's use, but I could put one on the projector very quickly.
Yes. Could we do that, Mr. Esty?
Certainly.
Thank you.
Excuse me one moment.
Thank you.
Just go off the record.
One sunny day on vacation. That's it.
That's like the Bruins fisherman.
It rained when we were indoors, so it was all good.
Okay, we'll go back on the record.
All right, thank you, Mr. Revin. Could you please turn to the page that you previously indicated would demonstrate the previous versions of the Act 537?
Section 1.1 generally is entitled Previous Wastewater Planning. There are subsections A through Q that reference prior sewer planning. I think would you like me to turn, I think the table of contents would demonstrate what has been done before. Would you like me to turn to page 1.1?
Really see, is there any way to zoom in just a little bit?
Sure.
Or maybe I can put on my glasses.
And just let the record show that Mr. Revin is referring to Volume 1, the table of contents in Volume 1 of the Act 537 plan update.
So it would appear to me, at least from the page that we're looking at, Mr. Revin, that East Brandywine Township had a sewage plan in effect beginning in 1977. Or did that say 97?
You gotta move the cursor.
The cursor's in the way for us. That's why I can't. Yes, 1977.
Drive and.
That's okay. You got it?
All right.
Would you agree with that?
If you would allow me a moment, I see that Section 1C references East Brandywine Township Sewer Plan, Act 537 Plan dash 1977. That does appear to be a prior 537 plan.
And following that, line B references an update or revision in 1999, correct?
That is the way the table of contents reads, correct?
And then there was in 2001 an Act 537 plan special study for Guthrie'sville area, correct?
I'm sorry, would you write a letter to help me find it?
Oh, E.
E, yes. E reads Act 537 Plan Special Study for Guthrie'sville Area 2001.
And in, if we're looking at letter H, that was in 2006 through 2016. There were revisions relevant to the Apple Cross development and its sewer facilities plan, correct?
The table of contents indicates there are sewer facilities planning modules for a period 2006 to 2016.
And another special study at item K for Guthrie'sville in 2012, correct?
That is what the table of contents says, yes.
And if you could turn to the page relevant to item K for me.
Okay, I'm looking at page 1-4.
And item K, correct me if I'm wrong, deals with the Guthrie'sville sanitary sewer flows and a special study for rerouting. Would the applicant's property be included, is it your understanding, in the quote-unquote Guthrie'sville area?
I do not know.
Mr. Okay. Mr. Revan, I'm sure you don't recall because it's been a while now, but applicant introduced Exhibit 40 earlier in, maybe even in the first hearing.
Thank you.
Can you easily identify the applicant's property on this?
Yes, there is a characteristic of it that is unexpected to me, but I can point to the area, yes.
Okay. And is it included within the red circle that is overlaid on top of the plan?
Yes.
And is that relevant to what is titled the Guthrie'sville Master Plan, Guthrie'sville Village?
Yeah, the document that you have shown me is map 17 of the Guthrie'sville Master Plan, Guthrie'sville Village concept.
Okay. Now, the Exhibit T4 that we were discussing earlier, or excuse me, T4, which is the excerpt from the 2023 Act 537. Do you recall when the township first convened the committee for the consideration and preparation of this document, for this update?
I do not recall a year or a month.
In any event, it was adopted in 2023, and would you agree with me that that was after the submission of applicant's sketch plan in 2019?
Yeah, I would agree that 2023 is after 2019, yes.
Thank you. And earlier, I agreed to substitute our Exhibit A15 for the current Table 5-2 that's located in Exhibit T4. But our A15, does that look familiar to you?
It looks substantially similar to the Table 5-2 that appears in Exhibit T4.
And would you agree with me that other than the change in footnotes, it does reflect the same properties and the same numbers, both for treatment capacity and disposal capacity for those parcels?
If you give me a moment to put the two side by side, I'd be happy to testify to that, but not from memory. I'm starting to see differences that are more than my short-term memory to summarize.
Well, excuse me, with respect to what's referred to in both documents as the Winters Tract.
Okay, as it relates to the column entitled Winters Tract, both documents reference a footnote 2. The now withdrawn Table 5-2 references a footnote 6. The second column for units both reads 154. The third column for treatment capacity, or gallons per day, both reads 26,950. And the fourth column, which is disposal capacity, addition and demand, gallons per day, both read 13,475.
Mr. Redding, when you undertook the committee to prepare T4, did you advise any owners of properties that were affected by the updated Table 5-2?
I would again refer to the full document for a history of the, I do not recall what public notice was part of the process. I'd previously testified that at least some part of it was a survey to landowners. So I know there was a public involvement component. The details I do not know offhand.
And what about notice to affected property owners when it came time for the adoption of the March 2023 Act 537 plan update?
Again, do not recall details of the public notice.
With respect to T5, which is a letter to you dated January 25th, 2024, indicating that the Pennsylvania Department of Environmental Protection approved the update to the 537 plan. Did you share this letter with any of the affected homeowners?
I do not recall doing so.
Did you publish it in any local publication, newspaper or otherwise?
I do not recall doing so. It is available on our website, if that is anyone's definition of publication.
And when you were looking through the various alternatives with Mr. Foley in T4, and specifically Table 5-1, which is on page 5-5, And I noticed that the Winters tract only has one X that applies to it for purposes of the focus area alternatives, and that would be alternative A, correct?
Correct.
And that would be public sewer to the Applecross treatment facility, correct?
Correct.
But you, then you testified that the alternative that was adopted ultimately was alternative G, correct?
Correct.
And so the alternative G with respect to the property subject to this application, is it your understanding that that would require an on-lot disposal system to be implemented?
No.
Okay. What is the impact of alternative G with respect to this property?
Well, to the extent that the proposed solution is to address failing septic systems, I am not aware of a septic system existing on the site, and therefore it's no applicability.
No applicability.
Correct. When the township implements a sewer management program to monitor the performance of on-lot systems, it would not pertain to this parcel because, to the best of my knowledge, there is no septic system on the site.
I would only suggest to you that there is, because there's an existing commercial building on the property.
That is news to me.
I think it's been there longer than you've been alive, but,
Excuse me, can I ask for a clarification of that one statement? I'm certain that the existence of a commercial use on the property is not what was news to the witness. Can we ask that clarification?
yes.
I am unfamiliar with the means or even if the property generates septic or how it is treated in the current configuration. That it is a commercial use is known to me.
Thank you.
And if it were up until a couple of years ago, regularly housing and employing up to 20 employees, would you presume that there was a sewer system online?
I have no conception of the interior of the structure. I testified that I don't even know if it has a bathroom. So, and if it does, how the waste is treated from that property.
And was that information that may have been relevant to the committee's review and preparation of the update for the Act 537? In other words, how did the committee take into account the needs of this property
I think
with respect to the adoption of relevant alternatives that have been identified?
Okay. I think we're talking forgive me from deviating from the question answer just briefly. The sewer management program is the township's plan to address failing on-lot systems. I would not characterize the township's plan for the redevelopment of that parcel to be the reuse of the existing system.
I believe you also testified that the purpose of the plan is to make plans and take relevant considerations for future development.
Correct. If I may, there are plates at the end of this. I'm looking now at Exhibit T4. Plate 5.1. No, actually, I think that's a thing that's not quite in evidence now. Sewer service areas are maybe entered as a township exhibit. And I would submit that the parcel is located in the Applecross wastewater treatment service area. And I would expect the redevelopment of that parcel to connect to Applecross.
I don't have any other questions. Thank you.
Thank you. Mr. Foley, any redirect on this issue?
No.
It's now 8:36 PM plus or minus. The board is willing to go till 9 o'clock if the parties want to.
I think we could get done with this witness.
Okay, very good, thank you.
Thank you. This is, minute. Ready?
Are there any
Yeah.
redirect questions on this topic?
There's a different line of questioning about a different topic.
Okay, very good.
And just to, without testifying, just to set the stage, the issue is with regard to provisions of the current ordinance, as to which I believe the testimony will establish. There's a, as Mr. Raven calls it, there's a broken link. I call it a broken cross-reference within the ordinance, where one section of the ordinance was changed historically, and other sections of the ordinance that previously cross-referenced the old ordinance were not updated to correctly refer to the new ordinance. And I just want him to testify about that for the record, so that hopefully the board can understand how it is that those sections of the ordinance are somewhat confusing.
Okay, thank you.
Thank you. Mr. Raven, I'm showing you excuse me, what's been marked as Exhibit T6. Do you have it there?
Sorry, which one?
T6.
Yes, I have Exhibit T6 in front of me.
Okay, and just to move it along, can you identify this as an accurate copy of the current ordinance section 399-13.1 entitled Riparian Corridor Conservation District?
Yes.
Thank you. Again,
When you say current ordinance, Mr. Revan, this is the version of section 399-13.1 of the Township Code, which is currently in effect as of tonight.
Yes, it exists in our physical copies and on the online published version of the Code of East Brandywine Township.
Thank you.
and it is the version in effect as of the date of this current conditional use application, correct?
I know of no change to this section at any point during this application.
Thank you. And again, I'll note for the record, the highlighting is mine, drawing your attention to page 4 of that exhibit. Is that the section that is intended to describe what uses are permitted within the outer riparian corridor conservation district?
Correct. Parentheses 2 is under the header uses, C, uses permitted in the riparian conservation district. Section 1 describes the first 50 feet of a designated riparian district. Parentheses 2 says within the remainder of the riparian conservation district. Yes.
Thank you. So when you then follow that lead to current section 399-13F of the zoning ordinance, do you find a list of uses permitted within the flood fringe or the approximated floodplain area as subparagraph 2 suggests you should?
You do not.
And you're referring to Exhibit T7?
We're now referring to T7. I apologize. Mr. Raven, can you identify Exhibit T7 as a copy of the current, presently in force, Section 399-13, entitled Flood Hazard District of the Township's zoning ordinance?
I'm going to specifically look at the editor's notes at the top of Exhibit T7 describing the history of this passage. It references that it was updated in August of 2017 by Ordinance 2 of 2017. This, I believe, to be the current version of 399-13 Flood Hazard District.
Thank you. And when one turns to subsection capital F of that ordinance, as we were directed to by the previous section, what is the heading of that current section, subsection capital, current section F?
I mean, I'll stipulate that the code is what the code is.
Yeah, thank you. I'm trying to establish where it came from.
Based on the cross-link, one would expect to see in this section a list of the uses allowed in the remainder of the riparian buffer. The section F does not appear to reference any uses allowed any uses at all.
Thank you. And are you familiar with the process by which the current section 399-13 was adopted by the township?
Yes.
Drawing your attention to Exhibit T8, can you identify that?
T8 is the minutes of a Board of Supervisors meeting that occurred on August 16th, 2017.
And again, highlighting being mine, on both pages 2 and 7, do those sections refresh your recollection of why the township was adopting a new or revised section 13 of the ordinance?
It does.
Why was that?
The section of code 399-13 is required as a prerequisite of participating in FEMA's flood insurance program. FEMA, every 10 years or so, updates flood maps and requires municipalities to adopt revised restrictions of what is allowed in the flood hazard district. In 2017, the board adopted the new version of FEMA's rules.
All right. Now, until the new section 13 was adopted, drawing your attention to Exhibit T9, can you identify that as a copy of the previous ordinance section 399-13 that was in effect until the new one was adopted in 2017?
Right. I note that it does not have the editor's notes at the top, as does Exhibit T7, and therefore I identify this as a earlier version of the contents of 399-13.
At my request, did you look back through the history of the adoption of the amendments and have the opportunity to conclude whether or not this was the version in effect at the time that Ordinance Section 13.1 made the original cross-reference to Section 13 capital F?
Yes, I'd say T9 is a snapshot of the way the code appeared in February of 2017.
Thank you. And when one turns to Section 13 capital F of the previous version of the ordinance, does one in fact find uses permitted in the flood fringe and in the approximated floodplain areas?
Yes.
Again, I'm not going to ask you to interpret ordinance, but have you reviewed the uses that were permitted under that ordinance section?
I have.
Did you find any permitted uses in those districts of permanent structures, residential dwellings, or townhouses?
With the caveat that I do not service the township's zoning officer, I did not see that those permanent structures would be allowed.
Thank you. Also, that old section, capital F, contains internal cross-references For example, on page 5, under the heading of uses permitted as of right, the first entry is, quote, uses permitted as of right within the floodway as provided in subsection E above, period, unquote. Again, I've highlighted subsection E, and again, without asking you to act as a zoning officer, from your review of the uses permitted as of right in subsection E, did you see any permanent structures, dwellings, or townhouses permitted?
I did not.
And then, lastly, under subsection F2 appears the list or the heading, uses permitted by special exception. And again, there are cross-references to the preceding subsection, capital E. From your review of those ordinance sections, did you see any uses permitted by special exception that would allow for permanent structures, residential dwellings, or townhouses in those districts?
I did not.
Without presuming on what the legislative intent may have been back then, if this board concluded that it should now look to the uses permitted in the current ordinance, section 399-13, which is again T7, is there a section of T7 that lists uses permitted within the flood hazard district? I'm going to draw your attention to, I believe it's capital N as in Nancy. On page 10 of Exhibit T7.
I can confirm in the current flood hazard district, subsection N, there is a list of uses that are permitted.
And again, without asking you to interpret the ordinance, from your review and mine, did you see any permitted uses of permanent structures, residential dwellings, or townhouses?
I did not.
Thank you. That's all I have.
Is done. Any questions?
Without getting into legal interpretation necessarily, Mr. Revit, is it my understanding that your dialogue testimony right now consisted of an implication, if not an opinion, that the township's code does not permit applicant's property to be used for the uses designated in the underlying zoning district assigned to the property?
Okay, I'm unwrapping that. It is my testimony that when you look to the uses permitted in the second 50 feet of a riparian overlay district, in the current code, it refers you to a section of a different hazard district, the flood hazard district, wherein nothing that makes sense relative to uses is described.
Correct. So essentially the code reads, for uses permitted in these areas, see this other section, and then you go to the other section and it's kind of like a ha 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 ha, you can't do anything. Glad you cross-referenced over here. I mean, essentially that's what happened, correct?
I wouldn't characterize it quite like that. Can we look at the referring section in the copy of the flood hazard district, the floodplain?
I believe I understood that you were talking about F of 399-13.
Right. I push back on the sort of implication that it was deliberate or right.
The outcome would be the same.
The outcome is that a reader would be very confused being referred to a section that appears to have no reference to uses that are permitted.
Correct. I would agree with that. Now, with respect to the page 10 of T7, I believe is what we were just looking at. And that would be 399-13N, as in Nancy, use regulations, and it's not necessarily relevant to 399-13.1 because there is no cross-reference to this section. Would you agree?
I'm very sorry, your brain works far faster than mine. We're using T7.
T7 on page 10, you were just looking at the use regulations with Mr. Foley.
Correct.
And would you agree with me that under N1A, this new updated code section essentially says uses in the flood hazard district, one of the things permitted is agriculture, correct?
Yes, the first item under 399 in parentheses 1 subsection A is agriculture.
Okay. And you would also agree with me that subsection E permits for parking, correct? Pervious parking.
Pervious parking customarily incidental to any of the foregoing permitted uses.
Thank you. Now, looking back at 399-13.1, specifically subsection D is invaded, and that is on page 4 of Exhibit T6.
I'm sorry, which section?
D.
Thank you.
How about T6, page
T6,
4,
page
subsection 2.
Subsection D2, which reads, the following activities and facilities are specifically prohibited in the riparian corridor conservation district. And then, would you agree with me that B, subsection small b, specifically prohibits the use of fertilizer, pesticides, and herbicides, correct?
That is what the passage says, yes.
Objection.
That seems consistent.
Objection. It's misquoting and misstating what it says. It says, use of quote, use of fertilizers, pesticides, herbicides, and/or other chemicals in excess of prescribed industry standards or the recommendation of the Chester County Conservation District, period, unquote.
Okay. Thank you. I mean, again, I'll stipulate to what the code says, what it says. Does that sound consistent with the limited use permission of the other section for agriculture?
Okay.
Would you agree that the two are at least contradictory?
Not necessarily. I would say that let's say there's an agricultural use and fertilizers, pesticides, and herbicides and other chemicals, so long as they are within the prescribed industry standards are used, that they're not prohibited.
And with respect to subsection small d of the same section, it says parking lots are specifically prohibited, correct?
Okay, so small d could
T6, we were just looking at.
okay, small d, yes, reads parking lots, period.
Correct, as a specific prohibition. And yet in 399-13N that we were just looking at, it says that the use is permitted. One of the only few uses permitted is pervious parking, correct?
I do recall that, yes.
Do you think that that's a contradiction between these two sections?
Yes.
Thank you. I have no further questions.
So your statement was that by virtue of the cross-reference in an existing ordinance to a subsection in a previous ordinance, the reader would be confused. Can you tell us how that happened? That this section was allowed to cross-reference a section in an ordinance that got replaced?
Based on my familiarity with township practices, I can infer how that happened. The township became aware that FEMA had a new firm map and had new restrictions on the use of land use within the flood hazard district. In all likelihood, and you can read more directly in what Mr. Pearsall presented to the board in the minutes of the meeting that was previously, the ordinance task force would have diligently reviewed that draft ordinance and recommended it be adopted by the board, with being unfamiliar that elsewhere in the code, references were being broken. And I use the word link because I interact primarily with this record in an electronic format.
Thank you. If this board wanted to interpret its current ordinance most liberally in favor of an applicant by going back to the previous ordinance and looking at the uses that were permitted under the old ordinance, based on your, again, not asking for interpretation of ordinance, but based upon your review, would it find any place in an existing ordinance or in a previous ordinance where permanent structures, residential dwellings, or townhouses were ever permitted in the outer riparian buffer district?
Not to my knowledge.
That's all I have.
Just one follow-up, Mr. Roden. Would you agree with me that if the township undertakes a development project of any kind within the boundaries of the township, it would be obliged to adhere to the requirements of the code, dimensional and otherwise?
So when the township receives an application for a land development,
If the township were to undertake a development, so a public structure, for example.
I have limited experience with this. May I use an anecdote as perhaps an answer? When the township installed the LED sign in front of our building, we did comply with the zoning code. Yes. When the township built a parking lot at Bondsville Mill Park, we did install a stormwater BMP. I can't speak globally, but I can speak anecdotally. Yes, the township complies with its own land development regulations.
That's all I need. Thank you.
And if a township needed relief from its own zoning regulations, does it have standing to apply to the zoning hearing board for relief?
That is perhaps a question best addressed to a zoning officer.
Thank you. You're right. No, nothing further.
Okay, we've reached 9:00 p.m. We're going to adjourn this hearing until July 17th, 2025. The hearing to commence after the conclusion of the Board of Supervisors meeting. The board meeting starts at 6:30 p.m. And that's with the consent of the parties. That continues. Thank you.
Thank you.